Good morning, ladies and gentlemen. My name is Sengupta. I'm moderating this session, which is provocatively titled Whose Data Is It Anyway? And I think there's a reason for this provocative title, which is that we are now at a stage where we are discussing fairly advanced questions regarding regulation of the data economy. And several incidents, as well as regulatory responses by countries across the world, has meant that it's a good time to be discussing what shape and form specific regulations should take. But at the same time, quite curiously, the first principles of data governance are up for grabs. So many people in this auditorium today would have differing views if I ask them the question, do you own your name? What about selling your sexual orientation? These seem to be slightly absurd questions, and there could be two views on whether you own these pieces of information about yourself or not. And what do we have in mind when we are talking about ownership of personal data? Is it ownership in terms of a true proprietary right? Or is it ownership in terms of autonomy, that the individual should be allowed to decide for herself what she wants to do with her personal data? These are some of the questions that we'll be discussing in the course of the next hour. We've got a very eminent panel for you today. We have Paula Kift, to just going from my right to my extreme right. We have Paula Kift, who's from Palantir Technologies and looks at privacy and civil liberties. Will Carter, who's the Deputy Director and Fellow at CSIS. Sanjoy Joshi, the Chairman of ORF. Cyril Cuvillier, the Deputy Director of Strategy in ANSSI, and Ashwin Sastro-Subroto, the Executive Member of the ICT Commission of Indonesia. We are very grateful for everyone being here today, and thank you to the audience for coming out for an early start. So this is how we'll do this session. We'll have opening remarks of a maximum of 5 minutes from each of the panelists. I'll be fairly ruthless with the time. The time is in front of everybody. And then we can have discussions between the panelists and then some questions from the audience. Since Sanjoy said that he has the most big picture perspective from an Indian point of view about regulation of the data economy, I thought it might be good, Sanjoy, if you got us off to a start in terms of what you think these first principles of the data economy should be.
Thanks, Arghya. In my view, there is a deep divide today, and it's the whole debate on data has got polarized between two camps. One which views privacy as an absolute right, that holy grail in itself, that must be attained at any cost. And on the other side is people like, I would put Baidu's Robin Lee, who says that people will conveniently give up privacy for the sake of convenience. Every time we use Google Maps, we agree to share some of our data, and we do it for the sake of the convenience it gives us. So if you look at India, the supporters of India's massive Aadhaar program, we heard the minister yesterday talking about Aadhaar, would fall into Robin Lee's camp, who would say that, yes, we would gladly give up certain amounts of privacy for the convenience, for the privileges to offer us. And in India, frankly, the Aadhaar card is actually seen not as an intrusion of privacy, it is seen as a privilege of citizenship. People vie for an Aadhaar card, they want an Aadhaar card. It gives them direct benefits. Even though there are whole debates about the biometrics behind the Aadhaar card. But then you go into, ask an Uyghur living in Xinjiang, whether facial recognition software, also a biometric marker, is an intrusion or not. You're likely to get a very different answer. See, the point is that in terms of the data debate, we have two extreme opposites. On the one side, there's a cliff in between. On the one side, we're looking at the nanny state holding hands with nanny corporations, working for the public good and using data for the public good. On the other hand, you have the surveillance state and holding hands now with oligarchic capitalism and surveillance capitalism, and completely holding at ransom the lives of its citizens. So these are two extremes. Actually, the truth is that these are not two irreconcilable opposites. Every state, every society is somewhere in between. Every state, every nanny state has elements of the surveillance state, and every surveillance state has elements of the nanny state. It is also true of corporations. It is also true of every entity that actually uses our data and collects our data. So when we start talking of regulation, regulation must be that fulcrum, especially regulation in an open society needs to be that fulcrum which balances the possibility of these opposites. That yes, this can happen anywhere. And open societies, if they need to remain open, have to play that balancing game, have to make allowances, because any organization, whether it is a state, whether it is an agent of a state or an agency of a state, can swing from one side to the other. The same is true of corporations. Or a hacker can hack into any database and also have access to data. So that is why data rights, yes, need to be protected. There has to be regulation around data rights. Who owns the data is a very important question. And later on in this debate, I will get into the question of ownership. How do we need to look at ownership of data?
Okay. Thanks very much, Sanjoy. I think there are two interesting binaries there, as in between folks who prefer privacy over convenience and vice versa, as well as the nanny state and the surveillance state. And I guess the argument is right that these aren't really binaries, and we have to find that path in between. So Paula, turning to you, what can that path in between these two binaries look like?
So thank you very much also to the organizers for inviting me back to beautiful Delhi. It's always a special pleasure to be here. So I work at Palantir Technologies on the technical implementation of EU data protection law, which is one model for how individuals might have greater control over how their data is processed. But taking a step back from EU data protection law for once, I would like to reflect more broadly on the question as to what it might mean to have a property right in personal data, and to actually also reflect upon the underlying concerns I think that this question tries to surface, right? Because suggesting that it might be desirable to have a property right in personal data suggests that there is some issue with not having an individual right to data underlying. So what I'd like to dig a little deeper into is to what problem we're actually trying to address when assigning a property right in personal data, and whether such property right would be a solution to this problem. So I think the underlying issues have already been raised, a concern about what some have come to call surveillance capitalism, so others having the ability to make money off our data without sometimes our explicit knowledge or consent, that we might feel like a property right in personal data might be a solution to, so that we can have greater control over our data. So let's take this idea seriously and think about how feasible such a right would be first, and then assuming that it is feasible, how desirable it would be. So in terms of feasibility, the way personal data is typically defined in comprehensive data protection laws such as the EU General Data Protection Regulation, but also forthcoming laws such as the California Consumer Privacy Act, is that it includes not only data that is directly identifying individuals, but also data that indirectly identifies individuals, which is a highly context-specific exercise. So this raises the question, how would you actually define the boundaries about what constitutes your data and that of others? And this question of the intermingling between your data and others also raises the question as to how you would delineate boundaries of personal data that might be shared. So if you take a selfie with somebody, how would you assign the property right or the money that can be extracted from that photo, say? But even assuming that it would be feasible to distinguish your data from that of others or your data from non-personal data, it's unclear what you would get with such a right. So it's actually unclear how valuable an individual person's data is. So to quote one estimate by a famous sociologist called Zeynep Tufekci in 2015, around that time she estimated that Facebook makes maybe 20 cents per user in ads per month. And this price is already taking into consideration Facebook's considerable market power. So what an individual's value would actually be is unclear. That said, this price might still be worth it for some of us. But some that might then also say, like, well, I actually have enough money, I don't need this. So then you're actually suggesting that privacy should be something that is only affordable in a way to those who can afford not to sell their personal data, which raises, I think, a more fundamental question that Sunjoy also raised, which is whether privacy should be conceived as a fundamental right, as it is conceived in Europe, or an alienable property right. That said, Some might already argue it does not change the problem that there are entities who do de facto own our data in a way, without sometimes our full knowledge or consent. So if a property right in personal data cannot feasibly address this, what might be some alternatives? So I think one proposal might be to conceive of personal data as a kind of collective good that different institutions such as private corporations, but also museums, schools, universities, would be charged different prices for. And such a collective data pool could, for instance, be held by the government. Though then, of course, this raises the question, the government is also an interested actor, right? So there would need to be high technical and organizational measures in place to prevent government abuse of the data as well. An alternative model that I also find quite attractive is perhaps to enhance an additional obligation on data holders to exercise duty of care on data. So a law such as the GDPR introduces individual rights, such as the right to access, or to deletion, or to rectify data that data controllers hold about you. But you could also conceive of adding an obligation on data holders to demonstrate that whatever way they process data is furthering the interests of the data subject, but also the community that it concerns. So these are just some proposals. I will leave it there and look forward to hearing from the others.
Thanks, Paula. As in, this is suggesting a way forward, in a sense that we should think about alternative models, perhaps building on the GDPR in some sense, but thinking about more explicitly about obligations on data controllers, particularly relating to what duty of care they owe to individuals. Cyril, if I could turn to you now, both with regard to personal data as well as non-personal data, what role do you think ownership can play? And maybe if you'd like to reflect on the alternatives that Paula has suggested.
Okay, thank you very much. I'm very happy to participate in this conference. I come from France, the National Authority for Cybersecurity. And so our perspective is to link data protection with network protection and more globally digital protection, digital security. So the question of whose data is it can be answered through very simple remarks. If it's my personal data, I think it belongs to me if I can correct it, or if I can have it corrected. So I have a fair relation with the one who is having my data in its computing system. If I'm an IT in a company, maybe data belongs to my company if I'm the one who is able to have my IT maintained and returned to availability after an incident. If I'm not able to have this organized, whose data is it? So here we make a strong link between data protection and digital security. And as a national authority for cybersecurity, we work very strong for various endeavors. One is awareness raising. We work at the national level and at the European level. Now, this is October. This is the European Cybersecurity Month in all Europe. Another one is training, because when you have an incident, the question of getting your data available again means that you know how to solve the problem. So we work very hard for training with various counterparts. It's a multi-stakeholder work to have this ability of training, and we also do training at the European level with an exercise called Cyber Europe. A third one is drafting technical and organizational requirements. Here it is a public-private partnership because we go in a co-drafting of those requirements, and once they are balanced from economical point of view to security point of view, we have them mandatory through regulation. So then we have a regulatory framework which is meant to implement security rules, notification processes from cyber incident to all those involved in resolving the problem. Inspections to make sure that the company would take care of the system and implement the appropriate requirements. And last but not the least, in case of major crisis, we would be able to force decisions to companies for the global system to be protected. So these were a few words to start with.
Thanks very much, Cyril. I think that's a very interesting construct, that if you can correct your personal data, then you own it. Because I'm just interested in thinking about what kind of ownership that is, and whether that extends to selling your personal data or alienating it or trading it in some shape or form. Because it might seem to be some conception of ownership, but whether it's exactly ownership as we understand it in all its forms, I think is a question that we could discuss. So Will, coming to you, you had some thoughts about ownership of data when we were discussing it earlier in the morning, as well as about this binary world that we seem to live in, where there are folks who are talking about rights and there are folks who are talking about data controllers being evil forces in the world who are hell-bent on eroding people's privacy. So could you give us briefly your opening remarks on the first principles?
Sure. I mean, first I want to thank the organizers here for having us. I think it's a privilege to be part of such a fantastic panel on particularly such an interesting and important issue. I worry a little bit that conversations around data governance today are framed in very negative terms. It's all about protection and preventing abuse. And to me, we should be thinking about data governance frameworks first and foremost from the perspective of facilitating responsible sharing and use of data. The value creation is, I think, obvious to anyone who owns a cell phone, drives a modern car, or uses pretty much any of the products and services that are a part of our daily lives today. And so just making sure that we always come at it as a first principle, as you said, from the perspective of let's remember that data has a lot of positive uses, has created a lot of value, and we want to make sure that we're figuring out responsible ways to facilitate that value creation. On the question of ownership, I worry a lot about frameworks based on ownership concepts because I think they're very limiting. For one thing, they are most easily applied to personal data, even though, as Paula pointed out, there are many situations in which they're extremely difficult to apply even in the personal data context. But as we look forward into a world where there is more autonomy, more cyber-physical systems, more use of artificial intelligence to define human behavior in physical space, I think non-personal data is going to be an increasingly important part of this conversation, and constructs that allow us to address concerns around non-personal data might be more effective. The other is that it puts the onus of managing the impact of data on the individual, who I think is generally not well equipped to exercise their rights and then to exercise effective oversight and governance. And I think we have to start moving towards a framework. I personally like a framework based on concepts of value creation and concepts of harm. Take the example that Sanjoy mentioned of facial recognition. Facial recognition, as much as some people will tell you it is a fundamentally evil or good technology, facial recognition is a tool that can be used for good purposes or malicious purposes. If I'm using facial recognition to, make your life easier, allow you to get on an airplane without, scanning your boarding pass 50,000 times, to me that's a great thing. If I'm using it to lock up millions of Uyghurs in Xinjiang, that's obviously a bad thing. But to me it comes down to how we use data is really the determining factor of whether it is a positive force or a negative force, and I think that our governance concepts should reflect that. The final thing I'll say is I would like to start these conversations and really start our thinking about this with the idea of transparency. One of the biggest problems that we have right now is that it is so hard to understand how data is collected and used by companies and governments around the world because there's so little information. Going forward, the landscape is going to change, the data economy is going to change, and we're going to need to be able to evolve our governance concepts as it changes. And the first the first starting point to me is understand what the data landscape looks like today as we create our first principles and our initial starting concepts, and ensure that we have that transparency on an ongoing basis so that we can continue to evolve our governance frameworks for data as the data ecosystem evolves.
Okay. Thanks very much, Will. I think there are some clear ideas there in terms of transparency and instituting a framework that doesn't put the onus on the individual who can't understand most of the time what's going on, and perhaps put greater accountability on data controllers who are dealing with it. And I think that's an interesting point, segue to Ashwin, to give us a perspective from Indonesia. Particularly, and I think this is going to be particularly useful because a lot of the debates around data regulation currently, even in the global south, focus around the GDPR. And I think, and I of the strong view that many of the concerns that countries such as India and Indonesia and others in the global south face are very different. And our situation in terms of where we are in the data economy is very different from countries in Europe. So, Ashwin, over to you for your perspective on regulation and the data economy in Indonesia.
Yeah, thank you, Chair. First of all, I would like to thank the ORF for inviting me in this meeting. It's very interesting because Indonesia currently is in the middle of preparation for the Personal Data Protection Regulations, Protection Act. It is still not yet finalized because this month our president will be re-inaugurated. And our parliament, we have a new parliament, so hopefully in the next session of parliament discussion, that will be the regulation of the personal data protection will be taken into account in the parliament session. So I hope I can learn a lot from this meeting. And I work in Indonesia, I work for the National ICT Council, and we are involved very much in this field. Now, first of all, in this data protection, we have to have the same understanding as how the internet is working and how data is flowing in this internet network, from ICANN, from APNIC, from PTI, and from so many operators, internet service provider, and so on. So we have to have the same understanding as how the data flows, because it is on that, based on that, then we can talk about how we will have to protect the data, who will run the certain root server, for example, and so on and so on. Secondly, we have to see the situation in the country. In Indonesia, for example, we agree that our personal data is our own data. But then we distribute that to get services and so on. And unless we agree in that data distributions, then the data should not be openly distributed. Now we have to give the data to many government offices to get their services. We have to give our personal data to many private institutions also to get their services and so on. Now in this data exchange, either we agree that the data can be distributed, or there are laws that arrange how the data should be treated. So it is based on these two things how the data is regulated in Indonesia. Now, next is how the data is regulated. First of all, as I mentioned, we have not yet the act on the personal data protections. So in this field, then the Ministry of ICT have set up personal data protection regulation in the level of ministerial decree. So it has to be protected like this, like that. No, I don't want to explain about this because it will take so many hours. Now, but it is based on that currently we are doing our personal data protections while waiting for the law to be discussed in the parliament in the next sessions. Now, finally, I would like also to see about the local situations. You see, Indonesia is a country with something like $3,500 per capita income, something like that, more or less. Now, Based on that, then we have to be to approach data security also on that basis. You can see, for example, you can see in Indonesia, for example, fiber optics cables are still hanging around in many places on the street. So it is like that because the financial situation is at that level. So in this case, I believe that we have to go for the data protections as well as internet protections. From that level, you see, we have to see what is important first and what is our next step. If you still have your fiber optic cable hanging around 1 meter from the ground, and somebody can cut it just so easily. So we have to take that into account first before we go into next actions that will take more and more financial fund and so on. So that's kind of things that I would like to share here, and of course, in the discussion, we will talk more about this. Thank you.
Great. Thank you very much, Ashwin, and thanks to all the panelists for sticking to time so diligently. I think it opens up a few themes that we can discuss amongst ourselves. The first thing that struck me when I heard everyone was that there are quite a few problems with ownership of personal data. There are definitional problems. There are problems in terms of putting the onus on the individual. But still, ownership of personal data, if we go outside this room where we are all fairly familiar with this space and understand the technicalities of it, ownership is a really popular idea. And people still talk about my personal data being mine. And it seems that as a symbol, it's still a really powerful symbol. So what's going on here? Why, despite the fact that ownership is riddled with the problems that you've said, why is it that it seems to dominate non-technical debates on privacy-related issues globally? I don't know. Would you like to start, Paula, and then we can take that forward? Or, yeah, Paula first, and then we'll go to Sanjay. Yeah.
Thank you. Yeah, I think the reason why this model rightly remains a popular concept to consider is partly because some architectural decisions made early on in the internet and some early business models have set us down the path where a lot of services are provided free of monetary charge, but now we have become accustomed to paying for these services in a way through providing our personal data. And I think that we have now reached a point where we are realizing as societies and private companies the adverse consequences that result from transferring an advertisement-based model that might work well, say in an online vendorship concept, say Amazon. If you like this book, you might also like this book, to the context of social networks where the suggestion might be, if your political beliefs are this, you might also enjoy this view, right? Where it narrows down our opportunities as societies to have meaningful and respectful debates. But it's hard, of course, both I think for individuals and for private corporations to move away from this advertisement-funded model to alternatives where, for instance, users might also be required to pay something, billions of users that have become accustomed to having a service for free, right? So shifting business models away from this, realizing the importance of maintaining some control over the way your data is processed, particularly in a community space, and the types of access you might have to reality effectively that is framed through private platforms. It's hard to move away from these business models. So then the question arises, well, if other entities make money about data, why aren't we not having greater control of this? I think some intermediary solutions, which also touch upon the issue that individuals might not always be best equipped to address these issues themselves because of power discrepancies, knowledge, the sheer overwhelmingness of how our data might be processed over time. So here the GDPR was one attempt, but again I would argue that it does not go far enough, particularly in putting the onus on data holders who are in a position to take greater care with regards to the individual and social impact.
So hold that thought for a minute, because we'll discuss solutions in a minute. Sanjay, just before you come in, maybe provocatively, if I could say, do you think that if services on the internet weren't free, as Paula suggesting, do you think that the debate on ownership would have been very different?
Certainly it would be very, very different because as I started saying right in the beginning that we are in a way trading data for the convenience which free services give us all the time. But beyond that, let me get back to your primary question which you raised. Sure. Where is this debate being framed? Why is this debate being framed in terms of ownership? I think it's being framed in terms of ownership because legally we like to build regulation on known frameworks rather than unknown frameworks. And when we start talking about data, the immediate reaction of most governments has been to treat it like a resource. Now, there are certain problems when you start treating data as a natural resource. The fundamental problems there. So the first problem which arises is that if you start treating data as a natural resource, then a natural resource in most nations is held by whom? It is not held by you or me. It is held in a fiduciary capacity by the government, which holds it on behalf of that abstraction called the people of the nation. That is not you or me. And that it can be used, therefore, for the public good. Now, you're getting into a resource debate here. Now, anyone then who is collecting data is also a data fiduciary, who's becoming, to certain rights of ownership are passing on to the fiduciary. And as has been said, Cyril said it very aptly, that data, ultimately it matters what use you put that data to. Data, there can be good users, there can be bad users. There can be people and agencies within well-known organizations who will misuse your data. You need to be protected against that. At the same time, data, yes, has its uses. Data is definitely gives you a lot of convenience. So the resource model actually, when we start talking as a resource, there are problems. I mean, I often love using a different image when I start talking about data. Rather than saying that data is oil or data is gold, I use the image of saying that we radiate data all the time. That is what we do. And it is not we who are radiating data. It's the devices we use, the interactions we have between people on Facebook, the interactions we have with our devices, with my refrigerator, with my car when you go into the Internet of Things. That is what is basically radiating data about me all the time. And yes, radiated data can be lethal if it is used for the wrong purposes. It can be lethal when it's used for the wrong purposes. But then every data, again taking the same analogy, has a certain shelf life. When you do a transaction with your bank, the bank sends you an OTP. Now, extremely lethal data if you share, if it becomes public knowledge immediately. Anyone can hack into your account and steal whatever you have. Within 5 seconds after you used it, that data is useless. It can be shared with anybody you want. It is non-lethal data. So data graduates, data moves. It has a shelf life. Data beyond a point can be used, can be made public. No, celebrity data after their deaths becomes public. The most intimate details become public. So data, to think in terms of ownership as property is a wrong idea. We need to conceptualize data very, very differently and then think of the legal frameworks in which we tend to frame this debate. And that is where Paula's and Cyril's point comes in. They just start thinking in terms of value creation out of data. Who's creating value? At what level that value is being created? It's not data itself. Data is ubiquitous. Data is everywhere. Data is a dime a dozen, is cheap. It's not very expensive. You go on the darknet, you will find all the data you want.
That's right.
About your credit cards also, right? But the fact is, what use is being made of data, who is adding value to data, what value is being added to data, that is where the debate comes in, and we need to start defining, breaking this debate down into rights of use, extent of use, nature of use. That is what we should be doing.
I think that's great. Yeah, Will.
So I completely agree with Paula and with Sanjoy. I would add in one small thing, which is I think part of the appeal of the concept of data ownership in the broad public sphere is that it implies agency for the individual. To me, that's actually the most important kind of driver of that public framing, and particularly the way that political leaders talk about data. And I think it links to another thing, which is this is all happening in a context in which the average person is massively distrustful of both companies and governments. And so when you say, I am concerned that my data is being used in ways that are harmful to me, I don't trust either governments or companies to address that. I want to be empowered to address that. I think that's when you devolve back to these concepts of ownership that say, I individually have not only the right to control my data, but I should be empowered in the same way I am to protect my property, to protect my data, to protect myself from the way that this data is used. So to me, it's the concept of agency, and I think one point that to me derives from this is we need to start talking about how we can facilitate individual agency through other governance models, and it's also the issue of trust. We need to figure out how do we restore trust in other groups within the data ecosystem that can more effectively protect us from the malicious use of our data than we can ourselves.
Sure. So Cyril, you wanted to comment on that?
Yes, of course. Indeed, we've been saying from the beginning that privacy could be at any cost for people, or it could also be a question of public good. What can you do for the data for the community? And there it comes a question of security again, because of course you have a debate with the company. Why has the data has been collected? For which purpose? And will it be used over this purpose or just for this purpose? But then you have the question of malicious use. If you have a data breach which breaks the law of the market because you have unfair advantage and you become profitable even if you got the data from a very different way, this is a real problem of confidence in the system, which brings people to ask for security at any cost of their data. So what we need to work on is really making sure that the systems that collects those data and gives value to it for a common good and that helps the company to be profitable are very strong by nature and that by design. And so this is what we do in ANSI, making sure that, as the GDPR would say in Article 32, the controller and the processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the user. So this is another question that comes with the question of being fair, ethic, and so forth. And maybe a last idea to add is that fairness needs to be read against a law that has been passed through a democratic process. It's not only a question that you should raise after an incident. It is something that we need to settle, bringing ethical and moral perspectives during the democratic process of it. But then the law is passed, and we know which are the rules for companies to be profitable and in a way that is balanced with the private, the privacy and the common good.
Sure. Ashwin, did you want to say something on that? Yeah.
Yes, thank you. Just to add to this discussion. First of all, the basic concept of the internet openness in Indonesia is that all data, all information can come to the country unless it is illegal. For example, pornographic, radicalism, things like that. Basically, you can connect to all those data. As a fact, in the Internet Service Provider Association survey in 2017, many Indonesians are using global intermessaging services, global communications, and so on. What does it mean? It means that when you register to that services, then you have to give your personal data. Another problem is that many Indonesians doesn't speak English properly now, within all of us here. Perhaps my English is the worst one, because we don't speak English daily, We don't speak English in the office, we don't speak English in the classroom, and so on, unless you go to international class, of course. But that is the situation. So when you apply for that services, you don't actually read the terms and conditions. You just enter whatever it is, then you agree, and that's it. Whether whatever is agreed, you do not really know.
I think that's the same whether you read English or not.
All right. Okay. Well, so because of that, it is the data is spread to many areas, you see. And one day, just a short comment on this. This also discussed in the open discussion like this. And the minister was asked about this data protection, and one of his comment is very interesting. Do you want me to close all those, all those Facebook, Instagram, and so on? You want me to close that, all of that, or not? The answer, of course, is not. So that is the fact that you have to face.
Sure.
Thank you.
I think let's now turn to looking at some alternatives. I think we've sort of skirted the surface around some potential alternatives to ownership being the fundamental construct of the digital economy. I was part of the Sri Krishna committee in the government of India's setting up of a data protection bill. Much like Indonesia, this bill has still not been introduced. But a construct which we felt worked well, instead of a construct of ownership, was placing fiduciary duties on all data controllers, whom we call data fiduciaries, because as Will pointed out, it's essentially a relationship of trust. You're giving some information in trust because you expect that it will be used in certain ways and not in certain other ways. And combined with putting obligations on data controllers to use information in those ways, and as Cyril pointed out, much like Article 32, having ex-ante safeguards in place so that systems are designed in a manner that incentivize privacy protective behavior. So we've had some ideas around alternatives across the panel. The idea of greater responsibility on data controllers, and also the idea around thinking about trust as the fundamental relationship between various actors in this ecosystem. So I'd like to get your thoughts on what alternatives we can think of in conceptualizing this relationship between the individual and the data controller, and what those enhanced responsibilities that you spoke of, Paula, and the enhanced duty of care looks like. So anyone is free for suggestions on what an alternative universe of data regulation might look like. Yeah.
Sure. So I think I can perhaps begin by elaborating why, from my perspective, the types of individual rights that we receive with regards to access, rectification, deletion are necessary but not sufficient from the perspective of ensuring responsible use of data. So I think this touches upon some of the limitations to these rights that William already pointed out, amongst others that, say for instance, if you think about these rights already, the types of individuals who are aware that these rights exist and who know how to exercise these rights will likely already be on the privileged end of the social spectrum. They will know about the regulation and they will know how to make use of it, which likely are not the same group of people who are actually likely to be adversely affected by biased data practices, right? So this might be a first issue. The second issue is, say you exercise your right to access, and you receive back a 45-page PDF with all of your information. Does this meaningfully inform you with regards to how your data is processed? What you do with this information? It's unclear, right? So again, the onus is put on the individual to go to a company, get the information, then what do you actually do with it? So I think these rights are very important. You should have this kind of transparency, but at the same time, there also needs to be a greater obligation of multinational companies holding personal data of billions of users to proactively perhaps perform social impact assessments similar to a data protection impact assessment, to consider the consequences that their processing might have, and perhaps to even be obliged to think about ways to align their interests with that of the data subject.
Maybe I'll push you a little further on this and take it to Will. Rights seem to place the onus firmly on the individual. But at the same time, Paula says rights are quite important. I sense a contradiction here. That if we don't want the onus to be on the individual who doesn't have a clue, but we want it to be on companies, why not junk rights altogether, or most of these rights, and adopt an accountability framework for companies and hold them liable if they're causing harm?
I mean, at the end of the day, the idea of holding companies accountable for causing harm is fundamentally rooted in the rights of their users, who they are harming, to an extent. And I think that, so to me, it's not a question of putting aside the concept of rights. I think the question is, where can we have effective interventions? So you start with transparency. What degree of transparency, to whom, under what circumstances is both feasible and desirable to make sure that companies and governments can be held accountable consistently. Second, on interventions, who has the resources, the time? I mean, one of the issues around privilege is who has the time to try to understand how all the apps that they use their data? I do this full time, and I don't know how the vast majority of the apps on my phone collect and use my data because I do not have time for that. But can we create entities within the system that have the expertise, the resources, the time to make effective interventions? What do they need to be empowered to do? And then how do we tie the accountability that they provide to the interests of the users that they are protecting? So then the third piece is, as we think about, from a governance perspective, this idea that data itself is not the problem. It's uses of data that are either positive or negative. How do we start to conceptualize in ways that can translate into concrete regulatory frameworks what adding value from data, creating value from data means, what harm means, and I think it has to be more broad than the traditional definitions of threats to your life and limb and property and threats to financial harm, which are the two kind of traditional concepts that we use. How do we define harm? And then finally, how do we think about how to balance the trade-offs between them? Because a lot of services will have the potential to do both. They will create value and they will potentially create harm. How do we balance those interests? How do we think about that from a governance framework from a local level all the way to a global level? To me, those are the kind of key questions that we have to get into.
And Cyril, one of the points that Will was making was with relation to transparency in design. And in your experience, how can we, very briefly, how can we achieve that transparency in design, or how can companies be incentivized to have privacy by design?
Yeah. Well, I think one of the aspects of the design is to be able to take into account the purpose for the company or for any people to use a system in which process of the industry with this software will be used. And so if you take into account what is done with the data from the perspective of the user, you reach a better level of resilience, because standardization is something, I mean, obviously we all in technical are positive about it, but it may not loses the perspective of the users. And this is something we see in case of incident. This is something we see in case of training. For example, again, the GDPR said that the owner, the controller may describe the likely consequences of the personal data breach. How may he know if there is not a conversation with the user? So I think we should have a more resilient approach from the beginning, and to help users be empowered in the way they put data in a system, in the way they understand what the system could, in which way the system could fail, how they could protect by themselves from this. So it's also a question of empowerment for the user.
Sure. Ashwin, some final thoughts on alternatives.
Yeah, just a short comment on this. I believe the world should have some sort of agreement, basic agreement, as how this should be solved. Now, bearing in mind that in the last meeting of ITU, International Telecommunication Union, under the UN, in their meeting in ITR in 2012 in Dubai, the world was split, because that time the idea is, what is the possibility for the ITU to lead the harmonization of the internet regulation, including the data protection and so on. And basically the world was split. Some of the countries would like for the ITU to lead this harmonization, while the other does not. So bearing with this in mind, then perhaps we have to come together again to review the ITR, to review the ITU cybersecurity agenda, as how is the role of the UN ITU in these harmonizations. Otherwise, if it come again into a split idea, split way of thinking, then the world will have some sort of harmonizations. And from my point of view, because ITU decision making is always finalized by the agreement of all the members, including all of those big and small countries and so on, perhaps it is time for the world to rethink their idea, where, to give the ITU, to ask the ITU, UN ITU to let the harmonization of in this field, in this internet field. Thank you.
Yeah. There are a couple of interesting papers about how the global data regulation discourse now is resembling the climate change discourse in the 90s. So maybe internationalization is the way forward, though we don't know whether that will get us very far. I think we've done well for time. Unless, Sanjay, you had some last comments, we're going to open it up to questions.
Just a
Yeah,
quick
sure.
comment on what you said about fiduciaries and
Yeah.
the question about fiduciaries and data. I have no problems with the fiduciaries' rights over data as long as all fiduciaries, no fiduciary is more equal than others.
That's right.
Depending on, as Cyril said, depending on usage. Now, any fiduciary can make any use of the data. The Economic Survey 2019 boldly says that the government should use data as a resource and monetize it. If it is going to be monetized, then there are different regulations and rules which are applied to agencies of the government which use data for those purposes.
That's
So no fiduciary can have preemptive precedent rights over any other fiduciary, depending on the use it is put to. That is my single point.
That's right. Depends on whether we are an animal farm or not.
Yes.
Yeah. Okay. I think we've done well for time. So we do have about 10 minutes for questions. So I'd request everyone to introduce yourself and keep it brief, and if possible, direct it to a single panelist. Yes, there's a question there.
Hello, hello. My name is Pavitra. I work with multiple provincial governments in India on direct benefit transfers. So my question is that, so what happens that there are many, there have been many governments which have been like fast movers who have collected a lot of data. There have been multiple companies who have collected a lot of data. But now that those 10% or may say 15% of the population, global population, which have leveraged already the data, goods of the data, have now understood that there also is a bad side of using data. And do you think that this now when we bring in data security or data ownership principle, it would require a huge investment in terms of technology such as distributed ledgers maybe, or creating awareness among people that they have this data and bringing in regulation. So this require time and capital investment. So till that time, so how do we handle this? How do governments who need to have the nanny state, as you said, who need to have this data, how do they handle it? Because now it has been disrupted and now like things have been stopped.
Understood. Will we take 2 or 3 together so that, yes. Sir.
Excuse me.
Yeah, we'll take one here and then take you. Yeah. Is there a mic? Maybe you have to go up to that mic. So why don't you give your question till the time he goes up to the mic?
Myself, Rahul, I'm from JNU, studying international studies and all. And my question is, sir, as Sujay sir talked about the value creation and all those things with the data, not contextualizing it in the sense of ownership. Sir, do you not think it also will leads to what we can say the value destruction? Like if we can consider the global environment in which populism and authoritarian governments are increasing, they could use these data to map what we can say separatist tendencies or to kill the civil dissent in the people. So do you not think there is a transition if we consider the data from the liberal democracies and the values they propose to more illiberal democracies?
Sure.
Thank you.
Okay, my name is Dr. Sharma. Does every data needs to be protected? Is there any classification for commercial, non-commercial, and sensitive data from the security point of view? And who should be the owner of different type of data, even if it is collected by Facebook or Google?
Sure.
Thank you.
Thanks. Does anyone want to start off with any of the questions on classification or on the nanny state? And yes, Sanjay.
I can take on the one on the nanny state and data security.
Sure.
See, data security is an ongoing work because technology keeps on moving. What is secure data today may become insecure data tomorrow. So you keep on moving to different systems of providing security. And eventually when it comes to the data repository, let us understand one thing, that no data is ever 100% secure. No one can guarantee data security. You have a right to life, but that does not mean you will not, when you step outside, you will not be mugged. You will still be mugged. You can still be mugged. So similarly, states cannot guarantee your security of data 100%. They can give you rights, they can give you certain privileges, certain compensation in case there is a breach. I mean, it is yes, a case for civil action. But 100% data security, I do not think any data repository, whether it is a private company, whether it is a government, can ever assure you. And anyone who's doing that is lying through his hat. Let us please understand that.
Yeah, Will.
So I'll respond to the question that's directed to me first. I completely agree, and I do think that, to me, that falls clearly under the concept of harms. So you want to have this balance between value creation and harms. Harms can include value destruction. I would tie an underlying thread of your comment also to the question about data classification. Another issue that I have with concepts of personal ownership of data and personal privacy is that they try to differentiate between data that is dangerous or risky and data that isn't. To me, any type of data, there's probably some fringe use case in which someone could do something really nasty with it. And even in non-fringe cases, I'll take an example of a use of data that is non-personal, that is not, that cannot be protected with ownership, but that I think has the potential for significant harm. And that is, governments are using data on flows of people in public space and behavior of people in public space, anonymized data. They're just looking at it in aggregate, but they're using that to physically structure public spaces in ways that limit the potential for large-scale organization, large-scale rallies, large-scale political events, large-scale expressions of discontent. To me, that is fundamentally worrisome. But a lot of it is data about what is the layout of the park. What are the flows of how do individuals move through the park? When large groups do congregate there, how do they actually behave? How does information and behavior move through those groups, which is non-personal data? Similarly, I think you can look at industrial data and the potential for really significant disruptions of core services as another case where I don't see how you can classify data as the risky data, the unrisky data, the data that needs to be protected, the data that doesn't. It's about harm and value creation, and that has to be the way that we try to structure our debate and our governance models.
Cyril, very quickly.
Yeah, just to say, but I guess you meant it, that value creation and harm are just something we would like to separate. And how to do so? It's to have a law and regulations that helps people who have right intention to succeed, because those requirements that we fix are just attainable if you make an effort. But they are meant to have those malicious use to fail. So the question is not to wait and see who is going to create value, who is going to create bad values. The question is to fix requirements, fix laws, fix a framework that will help appropriate companies who are transparent in their perspective to succeed because they will manage it, and others to fail because they will never pass through those requirements.
Sure. We'll take another round of questions. Did you have a question? Yeah.
Hi, my name is Dennis Bruce from Leiden University. I have a question that sort of pertains to both the comments on harm and on agency. And one of the problems is, when we talk about the value of data, economists have tried to sort of computate, okay, what is the value of individuals' data? And lo and behold, it's next to zero, because the business model is not modeled on the individual, it's on aggregate information and on sort of making buckets of people like us. So it's not actually about us, it's about people like us, and that feeds into the business model. So that gives you, so as Luciano Floridi says, none of us are really Moby Dicks, we're all shoals of anchovy, right? That's where it is. So how does that translate into agency? Because if your individual data is not really worth anything and you have no real meaningful hold on what the business model behind it is, even if you try to get into it, what kind of agency is possible? And also, I completely agree. I mean, classification is meaningless if the business model is meant on connecting all the different dots. Then, yeah, what does it mean that you have privileged information, very specific information, if you can aggregate it from everything? So that's one element. So how do you create agency in an environment where the individual, where all the rights are awarded to, where the individual is basically powerless? That's one. And the other thing that sort of translates to harm. So if a lot of the harms that come from this, usually they're not like thunderbolts coming from the sky, right? So it's all minor infringements, but they're still infringements. And most legal systems, especially in Europe, are based on individual harm. You do not have standing in a court unless you have an individual harm that you say, okay, I was connected to this. So what are the possibilities for thinking about forms of collective harm where collectives can actually go to a court and say, hang on, this development is going on, is emanating from this and this business model, this and this process. We want to have a say in court about this. So from individual to collective harm. Thank
Sure.
you.
Last word to, in answer to any of our panelists who wants to take that. Will, yeah?
So I completely agree with the concerns that you raised, and I think it gets to, first off, the reason why I think that we have to broaden our concepts of harm beyond financial harm. That's been one of the actual significant constraints on folks who have tried to hold companies accountable for some of the uses of data under the current system, in the US at least, and in Europe, I believe. But to me, the answer to both of your questions comes down to a question of scale. So how do you create that agency at a point of scale where an intervention is meaningful to the companies and to the governments that are using the data and is enough to shape their incentives, and also where you can start to understand the harm and how it and its systemic effects. So it gets to my point about, or from earlier, about how do we create entities that we trust, that operate at scale? What do we want to empower them to do? What do we want to require them to do? And then how do we link those, the authorities they have in the way that they choose to use them to the interests of their members or their users? To me, it comes to some of these ideas of data fiduciaries or data intermediaries, and there are a number of proposals out there. That, to me, is one model. Another is to put the direct onus on either the companies or the governments, although then you have to figure out what is your legal tool. As you said, how do you create that standing for a user to come in, challenge the use of the data, not because of the harm to them, but because of the harm to everyone? But scale, to me, is the answer to both the questions of how do we address harm, how do we start to quantify harm at meaningful levels, how do we actually shape incentives for companies, and then also how do we think about the issue of standing, the scale.
I'm afraid we are completely out of time. I know there are a few more questions. I'm really sorry to those who have those questions, but I'm sure you will have a chance in the subsequent sessions, and the speakers are all around to discuss it with them. So with my apologies, but I hope this has been a stimulating discussion with the dream of an internet where services might not be free, which will certainly not only be in English, and perhaps where ownership is not going to be the dominant construct for protecting personal information, but rather greater agency for individuals, however that may shape up. So thanks very much for joining us for this session, and please join me in thanking